Dictation start. Provided that where the person hereinafter referred to as predecessor, by whom any sum payable under this act, including the amount required to be paid, the credit of the central government under section 28B is not paid, transfers or otherwise disposes of his business or trade in whole or in part, or effects any change in the ownership thereof, in consequence of which he is succeeded in such business or trade by any other person, all goods, materials, preparations, plants, machineries, vessels, utensils, implements, and articles in the custody or possession of the person or succeeding may also be attached and sold by the proper officer after obtaining written approval from the Commissioner of Customs for the purposes of recovering the amount so payable by such predecessor at the time of such transfer or otherwise disposal or change. Full stop. Where the terms of any bond or other instrument executed under this act, or any rules or regulations made thereunder provide that any amount due under such instrument may be recovered in the manner laid down in subsection subclause 1, the amount may, without prejudice to any other mode of recovery, be recovered in accordance with the provisions of that subsection. Full stop. We are concerned essentially with subsection subclause 1 of section 142. Full stop. It permits that proper officer to deduct or require any other officer of the customs to deduct the amount payable under the act from any money owing to such person which may be under the control of the officer. Full stop. The refund is an amount under the control of an officer of the customs. Full stop. Section 142 therefore clearly entitles the proper officer to deduct or require any other officer of the customs to deduct the refund due to the petitioner towards the claims of rupees 13 lakhs plus rupees 3.13 crores which are the subject matter of the other proceedings. Full stop. The appeal is pending in respect thereof, but the amount has as on date been adjudicated to be payable by the petitioner. Full stop. This statutory right cannot be negated or diluted by the board. Full stop. If the word shall in paragraph 4.4 of the circular is not read as may, and paragraph 4 of the circular is construed to be a mandatory provision bearing absolutely the right of recovery adjustment, it would be contrary to section 142. Full stop. Had we not construed the word shall as may, we would have readily struck down paragraph 4.2 of the circular as being contrary to section 142 and therefore illegal. Full stop. In our view, however, the word shall must be read as may. Full stop. The validity of the circular is accordingly upheld, subject, however, to the word shall therein being read as may. Full stop. If paragraph 4 of the circular is construed as a total or an absolute bar against the authorities recovering any amount in excess of the amount deposited as required by paragraph 4.2, it would led to the most alarming result unjust to the revenue in the extreme. Full stop. For instance, if it can be established that upon filing an appeal and the deposit of the amount as per clause 4 of the circular, full stop.